Hello everybody and welcome to the legal education. In these videos I'm going to discuss one of the most important case law, that is Mohori Bibi versus Dharmodas Ghosh. This case law is very much important. This is a minor agreement. So please listen carefully, and if you have any questions please comment in the below and kindly subscribe to my channel so that I should make a new video every day. Okay, well, let's get started. Mohori Bibi versus Dharmodas Ghosh 1903. In this case, Mohori Bibi is a defendant, Dharmodas Ghosh is a plaintiff. I am going to tell the fact, issue, everything. Here, this is Dharmodas Ghosh's mother, this is Dharmodas Ghosh, this is Brahmadat, this is Kedarnath, this is Mohori Bibi. Here, Dharmodas Ghosh has mortgaged his property in favor of Brahmadat, defendant, when he was a minor. Dharmodas Ghosh, he mortgaged his property when he was a minor. Brahmadat was a moneylender in Kolkata. He took a loan 20,000 from Brahmadat. Dharmodas Ghosh took a loan from Brahmadat 20,000. In order to take the loan, Dharmodas Ghosh, he mortgaged his house as a security. Dharmodas Ghosh, he mortgaged his property as a security in order to take the loan from the Brahmadat. Here the transaction was done when Brahmadat was absent, was not there, and it was done by his attorney, name is Kedarnath, who had the knowledge of the plaintiff is a minor at the times of transaction. So here Brahmadat was absent from Calcutta and his business was carried on by Kedarnath, who was his attorney. When the mother of Dharmodas Ghosh came to know about the deals which was going on between her minor son and the moneylender Brahmadat, she informed by a letter to Kedarnath that Dharmodas Ghosh was a minor and she had been appointed by the court as a guardian of his person and property. She had also owned that anyone lending money to him would do that at his own risk. The letter was written on July 15, 1895, while the mortgage deed was executed on July 20, 1895. On the date of executions of mortgage deed, Kedarnath got Dharmodas Ghosh to sign a declaration containing a statement that he was a major. On September 10, 1895, Dharmodas, along with his mother, filed a suit against Brahmadat, stating that the mortgage that was executed by Dharmodas Ghosh was commenced when he was a minor. When this petition was in the process, Brahmadat had died and the further proceedings were done by his executor Mohori Bibi. The case was handled by Mohori Bibi. In this case, the question arises whether the deed was void under Section 2G of the Indian Contract Act 1872, whether the defendant was liable to return the amount of loan which he had received by the mortgage of property, whether the mortgage commenced by the defendant was void or voidable. The issue raised whether the deed was void under Section 2G of the Indian Contract Act. We know Section 2G of the Indian Contract Act 1872 defines an agreement not enforceable by law is said to be void. So, yes, whether the deed was a void, yes, absolutely. Whether the defendant was liable to return the amount of loan which he had received by the mortgage of property, no. Whether the mortgage commenced by the defendant was voidable or void, it is a void. In this case, Dharmodas Ghosh, who was a minor, had executed a mortgage in favor of Brahmadat, who was a moneylender. Dharmodas Ghosh's mother and guardians commenced an action against Brahmadat by stating that Dharmodas Ghosh was a minor when he had executed the mortgage and prayed for a declaration that it was void and unenforceable and should be cancelled. So here the Privy Council held that the mortgage executed by respondent was void, as the respondent was a minor and the money lender was not entitled to repayment of money, and declared the mortgage invalid. It is very much clear here. The court held that the mortgage executed by Dharmodas Ghosh was void because Dharmodas Ghosh, a minor at the time. The money lender was not entitled to repayment of the money and declared the mortgage was invalid. So, in this case, it is very much clear. Minor agreement is void but not illegal. In case of Mohori Bibi versus Dharmodas Ghosh, it is a very much important case law. The general rule is that the minor agreement is void, but for providing protection to the minor, various exceptions has been created by the court. The exceptions are when a minor has performed his obligations under the contract. A minor can be a promisee, but he cannot be a promiser. Number 2 is contract made by the guardians of the minor for his benefit. When a contract is made by the minor guardian and the contract is within the guardian's competence and for the benefit of the minor, he can sue on the contract. I hope you people are understand this case law, Mohori Bibi versus Dharmodas Ghosh. So kindly subscribe to my channel if you like. See you in the next class. Thank you.